Welcome to Cut to Legal.
Hello and welcome to Cut to Legal. I am your host, Kevin Rosenquist, here with entertainment attorney James Pacitti, a veteran entertainment lawyer and founder of Pacitti Law Firm. He's represented producers, production companies, actors, directors, writers, composers, and creators at every level of the business, from indie features to documentaries and multi-platform projects. After beginning his legal career as a trial attorney and litigator, James transitioned to transactional entertainment law nearly 20 years ago, building a practice focused on protecting creatives and helping them bring their projects to life. Really good to see you, James. Thanks for being here.
Good to see you too. Thanks for having me.
So this is a topic that obviously, as a podcaster or a creator, I'm very interested in. We're going to talk about contract clauses that creators really never should ignore. So let's start here. What is the most dangerous clause that you regularly see in entertainment contracts?
Well, it depends on the perspective. And what I mean by that, the perspective of a creative, such as a writer or an actor, or the perspective of a producer or a production company. For creatives, I would say the most common is overly broad grants of rights. And what I mean is you can have it overly broad in terms of temporal, the time, for instance, something in perpetuity that perhaps there should be less time on it. For example, if a writer was selling a script, very often a term that should be in there, if I'm the attorney representing the writer, is that if they don't produce that script in, say, 5 years or 7 years, it reverts back to and there could be, obviously there has to be exchange of money and things like that. But we're generally overly broad, also in circumstances where, again, with writers, but it can apply to actors where they give up rights to, say, sequels, prequels, spinoffs. For example, with a writer, if a writer writes a film, or it might be a pilot for a television series, or whatever it might be, it can turn into what we call a derivative project, and something that sometimes gets lost in the compensation and credit, which is what most people focus on, is that what if this turns into something more? Mm-hmm. It's not just maybe an opportunity for that writer to write that prequel, that sequel, whatever it might be. It's also compensation associated with it, because it's very common to get back end or contingent compensation related to the specific project that might arise from, say, a screenplay. But sometimes what's not considered is that what if there becomes a derivative project from that screenplay that gets turned to a film? Maybe it becomes a Broadway production. Maybe it gets turned into, nowadays, who knows, a podcast. So giving up all rights when you don't have to, that's on the creative side. For producers and production companies, I'd say a couple of things. One is pay or play. Pay or play and MFN, or most favored nations. For those who don't know, pay or play is that basically it's guaranteed compensation. Name actors will often want their contracts to be pay or play. That means upon the occurrence of a certain event, let's say arrival on location, or even as simple as signing of the agreement, their compensation becomes guaranteed. Okay. Almost no matter what. That could be a scary thing for a producer production company, because any number of things can happen.
Sure.
And so that's something they got to be very careful about, because they can ultimately be responsible for paying a very big fee to an actor who never acts in their film. And then most favored nations are also known as MFN. That's where, as someone becomes most favored nations, let's say for all terms, that means if anyone else comes along after this particular creative, let's say an actor, but someone comes along after this actor signs their agreement, and that subsequent actor gets more money than the actor who has MFN, most favored nations, their compensation gets raised to that level. And that's something that it's not carefully scrutinized enough sometimes by producer production companies, and then they bring in another actor who's getting paid more. Now they're going to pay both those actors. Mm-hmm. So depends on the perspective, but there's a number of clauses that can be very dangerous.
For creatives that see gigs saying work for hire, what does that actually mean? And should creatives be cautious about that term?
I mean, they should be aware of it. It's something that is very common in the entertainment business. It's something that's very necessary. Basically, work for hire means the hiring party, not the creator, is considered the legal author and owner of the work for copyright purposes. And it is something that is essential in any, let's say film production, TV production, anything where if you're a producer and production company, you must have everyone sign work for hire agreements. Anyone who contributes to the overall work, and let's say, for example, a film. So actors must be work for hire, producers, the director, department heads like makeup and wardrobe and so forth. So that because that's necessary for the production company to be able to distribute it because they have to have all the rights to the project. Let's say a film in order to distribute it. And if they don't have those who contribute to the work, again, actors, the writer, and so forth, then they don't own all the rights. So it's something that, yeah, they should be aware of it because an example that you're alluding to is if a writer must be clear that if they get hired, for example, to write a script, that should be a work for hire. It's something that it's appropriate for the be work for hire. However, they need to know that what they're writing is not going to be theirs when it's done and they deliver that product, the script, let's say, for example, to whoever hired them. The person who hired them owns it. And the writer in this example does not have any rights unless the agreement provides otherwise. So it's important. It's something that it's common and it's typical, and it's something that it's perfectly appropriate in many cases. But the creative should still be aware of it, and anyone who's engaging in a creative works needs to understand the implications of it.
When it comes to things like vague language, that's something that you often hear is like be careful. I've definitely signed some contracts where I've had someone look at it and gone, what does this mean? This kind of seems a little vague, a little broad. What kind of legal problems could that lead to down the road?
Lots of legal problems. In fact, a lot of, my experience is some of the truisms I use with people is that, most people don't enter into a contract with the intent to screw over the other party. My experience, my belief is that the vast majority of contracts that parties enter into, both parties have an intention to act in good faith and comply with the contract. The problem becomes when you have vague contractual provisions, the parties in some senses didn't have a total agreement as to a particular provision, perhaps, because it's so vague, it's so overbroad and ambiguous that one party might think, well, this means A, B, C, and the other party thinks it means X, Y, Z. And then if that provision becomes implicated in some way, becomes important, then arguments arise as to what it means. And that's where conflicts happen because there's a good faith belief on each side that the contract meant something different. So that comes up a lot because particularly sometimes, you see with studio contracts, because they are sometimes, one could argue, intentionally so, because the studios are the ones that, they have the power. So if someone has a problem with the contract, you got to go after a studio or a network. So it can create huge problems because if there's disagreement what a contract means, sometimes the only way to resolve it is litigation, and that's no fun for anybody.
Yeah, no doubt. And obviously things like deliverables, timeline, all that kind of stuff is included in any contract related to creating. Do you run into situations where those are not clear and where people have signed contracts that are unclear and causes problems?
Yes, I've seen that. It's happened in other circumstances, and then the obligations of the parties are not clear. And that, again, it's similar to what we just discussed, is that it creates disputes. For example, would be, and say, I've seen it with a writer for hire agreement, which we were talking about earlier, where a writer is hired to write a script or screenplay. And usually an appropriate agreement will provide the time periods, for instance, 12 weeks for the first draft, and then 4 weeks for the hiring party to review and provide notes, and then another number of weeks for a revisions, and then review again, and then polish. So you'll say you'll have 8 weeks, and then you have 4 weeks, and then you have 4 weeks perhaps. And then it's very clear what the writer has to do and what the other party has to do. When those things aren't clear, you can have a dispute because one party can be like, well, where's my drafts? And the party's like, well, I'm still working on it. Well, it's overdue. Well, no, it's not. So it can create conflict because there's just really no absolute clarity about the obligations of the parties. And you hope everyone can, in good faith, navigate it and figure it out. But ideally, the agreement is explicit and clear about it. So there are no disputes about what the respective obligations are.
Okay. I hear this more in sports contracts, but what exactly is a buyout clause?
Well, it can have a number of meanings, but typically speaking, in the entertainment industry, a buyout will basically all rights are being purchased for a fixed price. For example, until recently, Netflix, for example, would purchase a film from a producer production company, and it would just be a fixed amount, and it would buy out all rights. There'll be no back end, there'll be no royalties or any kind of contingent compensation. It's just you're gone. It's just kind of like when someone buys a car from another party. It's not like that other party gets opportunities to drive it on weekends or come and see it and sit in it and listen in the front seat. It's gone. It belongs to the other party, and that the person who sold it, all the rights have been purchased. They don't have they don't have an opportunity to get it back. They don't have any, like I said, royalties or back end participation. So that's those things. It's obviously another circumstance. Someone has to be absolutely clear that they're not getting it back. They're not going to be able to exploit it in another, in a year or 5 or 10 after that on some other platform or in some other manner. And so sometimes that's something that they have to be very clear that whatever you receive is all you're ever going to receive in a buyout.
Why would a creator agree to that?
Well, if the money is sufficient, it's now that's part of the reason it's changed a bit because content buyers we had the strikes and we had essentially kind of the implosion of streaming that all these production of these networks, in some cases studios, streamers were spending lots and lots of money to aggregate and create content to get subscribers. So there was a spending spree for a while. So these offers often were really good. So they would do it because it's a lot of money.
Mm-hmm.
And it would be enough. It's almost certainly would have to be where it's a situation where it's enough where the investors who maybe finance the project are getting their money back. The producers are seeing some profit participation. So I'm not going to quite say that, these were offers that you can't refuse, but they were sufficient to recoup. And that's often a hard thing, and especially independent TV and film. So that would be the case because you get everybody their money back and you make some money on it, though you got no potential for the upside of it. So that's what you're giving up. If this turns out to be a really successful project, there'll be notoriety perhaps around it, and that still can be very good for a content creator, producer, production company, whoever it might be. But you're not going to see any additional financial upside. So it's kind of like one in the hand versus two in the bush. That old saying. You're giving up opportunities that this is a huge hit, that there might be some back end, some net profits. So you're securing that you're going to get a nice payday, and probably that your financiers are going to get paid back.
Right. I like the offer you can't refuse. In this podcast, a Godfather reference is definitely.
Whenever you can, one of my favorite movies. So whenever you can make one.
Absolutely. So if a creator signs a contract and later they kind of feel like it was unfair or they regret it, do they have any recourse?
The short answer is no. Just if it's unfair. Courts are not there to protect people from making bad deals.
For making bad choices.
Yeah, you get bad choices. There are circumstances that if a contract can be voided because of very specific circumstances like unconscionability, fraud, duress, lack of capacity. And what those things mean, like lack of capacity, is maybe someone was mentally incompetent or temporarily so. Perhaps a very rare circumstance they were on drugs or alcohol when they signed the contract. Unconscionability is just the terms are so lopsided and ridiculous that to enforce it would not be conscionable. That's really rare, very difficult to prove. And fraud is a little more obvious. But for an example, it'd be they say someone buys a script from a party and that party represented that they had all the rights to the script, but they didn't. Mm-hmm. So that would be a basis to go back and say, whoa, I paid you money and you don't actually own all the rights to this script.
Right.
Other than those circumstances, no, if you make a bad deal, you're stuck with it.
What is a talent agreement? Is it separate from a contract or is that the contract?
No, talent agreement is a contract. Those are, we're talking generally talents. Talent can refer to a number of different occupations. You can say typically it refers to actors. But of course, if we're talking the broad entertainment business, it certainly would apply to singers and musicians and so forth, but it can also apply sometimes to directors. When you're talking about above the line, there's above the line and below the line. That's a reference to the budgets, but you have actors, producers, and directors and writers are considered above the line. So they might be called talent, all of them. But generally, you're talking about it's actors. And then that's, talent agreements in the context of, say, an actor. That'd be, for example, a performer engagement agreement. It's an agreement that provides the terms for actor to appear in a TV or film.
Okay.
TV show or film.
When a creator gets a contract and they're concerned that maybe it's sketchy, like they might not like the feel, the vibe of it. What do you advise them to do? What's their best course of action in that scenario?
They should consult an attorney. Because they may feel it's sketchy and it's not really sketchy. It's just
Right.
they don't know any better.
They don't know, yeah.
Yeah, because they can read these terms, not these terms, and it depends on the contract. There are just so many different agreements that arise in the entertainment business. From, like we just talked about, talent agreements, that some of these can be super long. They can be 15, 20 pages long, and they have all these terms. Sometimes when you look at a studio contract in particular, you'll see some things about FCC compliance and anti-corruption and morals clauses and in the standard terms and conditions, in addition to your principal terms where, you have credit, compensation, perquisites, control over image, publicity, things like that. You're going to have a lot of provisions in there that your typical, I would say, creative or talents may not be familiar with, and they might think this is sketchy. So why are they have all these things in here about insurance and workers' comp and a page and a half about rights? And so it's important to consult with an attorney. I mean, for any agreements, because you were talking about earlier about how someone signs an unfair contract. It's important not to justify our existence too much, but it's important to have an attorney look at it before you sign anything, because signing contracts has consequences. So if someone thinks something's sketchy, don't sign it. You may be wrong. It may not be sketchy, but you may be right. And in that circumstance, once you put your signature on that, unless sketchiness rises to the level, like I said, it's fraud, it's duress, it's coercion, it's unconscionability, you're stuck in that contract. There are ways to get out. Like if someone signs a contract and quickly regrets it, there are sometimes methods of getting out of it that don't have as dire consequences if you just let a contract roll.
Right.
So if there is an issue, the two things, you probably should talk to the attorney as soon as possible, and you should address it as soon as possible, because problems get harder to solve the longer they go on.
Yeah, that definitely makes sense. And for the record, I've been trying to justify my existence for decades, James, and it haven't gotten there yet. So you let me know if you do.
All right.
All right. Well, thanks for listening to Cut to Legal with James Pacitti. Visit PacittiLawFirm.com to learn more or to schedule a consultation. Don't forget to subscribe to our channel. Leave us a review. We greatly appreciate it. James, I greatly appreciate your time. Awesome chatting with you. Thanks so much.
Thank you. Have a good day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.